I was trying to put the finishing touches on a new article. I just sent you an article that really it kind of gets into the details as to why St. Louis has the status of a third-party beneficiary to the relocation policy. And I went back and looked at some congressional hearings and testimony by Paul Tagliabue. So I did like this deep dive looking at our archival research to show why these relocation guidelines really are intended to benefit cities and are not just created by the league, you know, on a whim as they see fit. And I never believed how the league had positioned the guidelines. And I felt that there was a story here and a deep history, and I found it.
Okay, I can't wait. I just got the article sent to me, by the way. How long have these relocation guidelines been in effect?
Well, there are two types of guidelines. The original guidelines were enacted in 1984 and 1985 as a result of a federal court of appeals decision in the Oakland Raiders case. So those were the original guidelines. And then following a spate of relocations in the mid-1990s, where there are quite a few of them happening, you know, simultaneously. I think St. Louis was sort of in the pipeline on one of those. You had, you know, Baltimore and Cleveland happening. So the NFL revised its guidelines following its they had consultations with the U.S. Conference of Mayors, and there were these negotiations that took place over a period of several months, and those negotiations ultimately led to the NFL amending its relocation criteria to better protect local markets.
Gotcha.
Well, today the NFL sings a different tune. The NFL forgets the history as to why the guidelines were created, and from the NFL's perspective, the cities were not interested or benefited parties. That these guidelines are only intended to protect the interests of the league in home markets and not the home markets themselves. So
gotcha.
The 84 guidelines and then the 99 amended guidelines, which are the ones at issue in St. Louis.
Gotcha. And even the 99 ones were put in place to protect the city, correct?
Yeah, absolutely. You know, if you read the amended relocation guidelines, it makes numerous references to local interests, community interests. Almost every single one of the criterion is a local market-centric criterion. And moreover, the cities are interested parties. The league has declared within these relocation guidelines that the cities are, quote unquote, interested parties that are entitled to notice and an opportunity to be heard. And in most litigation settings that I've ever been in, being entitled to notice and an opportunity to be heard and being granted interested party status gives one standing to challenge the policy or challenge the decision. That shouldn't be a shocking development. But what strengthens this is when you go beyond the guidelines and you look at the history surrounding their enactment and the circumstances under which they came to be, and the cities actually created the relocation criteria in conjunction with the NFL. There was a joint statement of principles, which was a written contract, a document that was jointly signed on to by the NFL and the U.S. Conference of Mayors. And that document includes all of the same relocation criteria that are now part of the NFL's amended guidelines. So the new policy simply took a work product that the city was a party to and incorporated them into the NFL's own policy. So the city's involvement and interest is replete throughout not only the main document, but in the incorporated document that was drafted shortly before the policy was amended. It's clear when you look at the history surrounding the relocation guidelines that the cities were active participants in crafting them and were intended to benefit from them. And there's correspondence from NFL executives. There's language in the joint statement of principles, which actually uses the word protects the interest of cities.
Okay, I'm going to put a clap here. I want to get news from today, your reaction. The NFL tried to get the location moved again. They failed. What's the result of this?
Okay, well, it was an expected outcome because the decision on whether to change the trial venue is a matter within the trial judge's discretion. And the case that the NFL tried to make is that the city of St. Louis is filled with all of these biased people. You wouldn't be able to find a single unbiased juror who has not been adversely influenced by all the pretrial publicity that in a city with so many hundreds of thousands of individuals, you cannot impanel, 12 neutral jurors. And that is a farce and a fallacy, and it's commonplace in trials in both state court and federal court for judges to issue detailed questionnaires to ferret out and identify any improper affiliations, associations, biases. This is a tactic that's really limited to high-profile criminal cases where a defendant might be fighting for his life, fighting for his liberty. It is rarely, if ever, used in a civil lawsuit, and it just simply can't be that the city of St. Louis lost its football team because, as the NFL says, there was disinterest within the city of St. Louis. But now that there's a trial, all of a sudden the light switch goes on and all these disinterested citizens in the city of St. Louis now hate the National Football League. They are irreconcilable. And I know this is a tactic that the NFL has played out over and over again in the appellate court system. They've already filed 10 writs and have now lost all 10. It's the legal equivalent of a Hail Mary, but there's no Drew Pearson or Roger Staubach to save the day here.
Very good. I love your football knowledge. Very good. So they've actually tried to get this venue changed 10 times, 10 writs?
No, the NFL, whenever the NFL loses what they consider to be an important trial court ruling, they take an appeal. And instead of taking a direct appeal as of right, which you're not really allowed to do until the whole lawsuit is over, there's a mechanism under Missouri law that allows intermediate orders, such as orders denying things that aren't final rulings, that permit the non-prevailing party to seek an emergency writ from the Missouri Court of Appeals, almost tantamount to an appeal. Those are rarely, if ever, granted. You need extraordinary circumstances and you need a real clear mistake made by the trial court. So the NFL is definitely shooting its shot. But they're basically 0 for 10, not from 3-court range. This requires almost a half-court shot. And they haven't come close on any of these writs. And they may have 1 or 2 additional ones left in the pipeline. But the reality is that the change of venue outside of St. Louis was never going to happen. I researched this issue myself, and I could not find a single civil case, non-criminal case, where a trial or appellate court changed the venue due to bias and adverse pretrial publicity. I mean, if there was ever going to be the first civil case, I guess this would have been the one, but it didn't meet the high bar for changing the venue of the trial.
I think a lot of St. Louisans, when this became a story, they said, boy, I can't wait to see Stan Kroenke and Kevin Demoff squirm on the stand. However, with their ability to appeal, wouldn't it be better if you want St. Louis to win is to take the settlement or to take the team as opposed to a trial? Because if they do go to trial, there's definitely going to be appeal and it could last for 5 to 7 years.
I don't think an appeal will last for 5 to 7 years. That's sort of a wish of the National Football League to maybe put some hesitancy in the minds of St. Louisans that you should take the money now because we're going to tie this up for years and we're going to ultimately win on appeal. And I don't think the NFL has a very strong hand on an appeal after a jury verdict, because once the jury gets involved and makes factual determinations, courts are much more likely, and courts do defer to jury determinations much more readily than questions of law decided by judges. So once the jury returns a verdict, it's a significantly uphill battle for the NFL to get a reversal on any issue other than a pure question of law. And there's certainly some issues around the existence of a contract, the proper measure of damages, and whether the city of St. Louis can get a disgorgement of the relocation fee and maybe claw back a portion of the increased value of the Rams franchise. There are more than enough issues of law for the NFL to feel that maybe they have a good chance on appeal. But I mean, you're talking about willingly walking into a jury trial where you know you're going to be hit with a minimum of a 9-figure, potentially multi-billion-dollar verdict, and you're going to want to take your chances on an appeal where the rate of reversal historically is less than 30%, where the league owners individually might be on the hook because Stan Kroenke is now welshing on this indemnity agreement. If I was one of those 32 owners, there's absolutely no way that I would want to incur that kind of risk, because if I roll the dice and lose, I'm going to have to be the one to write that check jointly and severally to the city of St. Louis. And not every owner has that kind of liquidity. The safer way for the NFL to make this case go away is the offering of a football team. It doesn't cost the owners anything to do that other than having to share their future revenues with one additional partner. And they were going to expand at some point anyway. I mean, it's not etched in stone that the NFL is going to remain at 32 teams for time immemorial. Expansion is always, looming down the road. And I could see a point in time where the NFL becomes 40 teams. St. Louis is easily one of the top markets if you look at 40 NFL markets. So I would take the team, not the money, because $1 billion or $2 billion is not going to be the monetary settlement here. The NFL is not going to settle for that much money, especially with the words "B" in front of it. But if they did, I would still take the team. This is the only way St. Louis will ever get a team, by holding the NFL over a barrel and having the leverage of a multi-billion-dollar settlement that you could jam in their ear. And having them over the barrel like that is a once-in-a-lifetime opportunity to secure a new team. It will never happen willingly. You think the NFL will ever willingly want to do business in a normal scenario with the city of St. Louis? This is all about leverage, and you have a lifetime of historic leverage right now, and it's only going to get larger as you get closer to the trial date.
You are awesome. That's all we need. You're the greatest. Let's stay in touch. Thanks so much for your time, Daniel.